Welcome to the Explainer. Today we're unpacking a really fascinating constitutional riddle, one that sits right at the heart of the world's largest democracy. Former Chief Election Commissioner S.Y. Qureshi actually came up with a brilliant metaphor for this. He called the Indian citizen's right to vote a statutory orphan. Now, if you're a UPSC aspirant gearing up for GS Paper 2, or maybe you're outlining a mains essay, you are absolutely going to want to pay attention here, because this analytical framework is incredibly valuable. Let's deconstruct this riddle together and figure out exactly how the Indian vote became a statutory orphan.
So let's jump right into the core conflict. In India, a nation that obviously prides itself on its democratic ethos, the very foundational act of democracy, which is voting, is legally treated as an orphan. What does that actually mean? Well, it means that despite being the absolute lifeblood of our republic, the simple act of casting your ballot currently lacks fundamental constitutional protection. It is, paradoxically, just left out in the cold.
To understand how we ended up here, here's our roadmap for today's explainer. We're going to cover 1. The decades of legal consensus, 2. The constitutional paradox, 3. The basic structure doctrine, 4. Article 326 as the foundation, and finally, the way forward. All right, let's kick things off with Section 1, Decades of Legal Consensus.
For literally over 7 decades, the Supreme Court of India held on to this really strict, unyielding consensus. It all started right at the infancy of the Republic back in 1952 with the N.P. Ponuswamy case. The court essentially established that the right to vote isn't a common law right, but strictly a right created by statute. And they didn't just say it once. They reaffirmed it in 1982 in the Jyoti Basu case, and then again in 2006 in the Kuldeep Nair case. Now, the underlying logic here, it actually kind of makes sense at first glance, because the Constitution doesn't expressly enumerate voting in Part 3 alongside our other fundamental rights. The court reasoned that Parliament enjoys immense latitude in prescribing voting qualifications and procedures through legislation. Specifically, we're talking about the Representation of the People Act.
To really grasp how stark this traditional viewpoint was, just listen to these definitive words from Justice O. Chinnappa Reddy in that 1982 Jyoti Basu judgment. He stated, "Fundamental though it is to democracy, the right to elect is neither a fundamental right nor a common law right, but purely a statutory right. It's literally a creature of statute. If the statute grants it, you have it. If the statute takes it away, you don't." And for decades, this was the undisputed law of the land. Which brings us to Section 2, the constitutional paradox. But the story definitely doesn't end there. As we stepped into the 2000s, the court started constitutionalizing the electoral process. They were transforming the voter from a passive statutory creature into an active constitutional actor. In 2002, the court ruled that voters actually have a fundamental right under Article 19(1)(a) to know the criminal and financial backgrounds of candidates, simply because democratic participation requires informed voters. A year later, in 2003, they drew a really critical distinction. They said, sure, the right to vote might be statutory, but the freedom of voting, making an informed choice, is a fundamental right. And then, jumping to 2013, the court extended absolute secrecy of the ballot, even to those who choose not to vote for any candidate, introducing NOTA. Now, this exposes a massive, glaring paradox, and it is a fantastic analytical point for anyone writing about electoral reforms. The Supreme Court has successfully constitutionalized virtually every procedural detail, every single mechanic surrounding the voter. Think about it. We have a fundamental right to know candidate backgrounds, a fundamental right to ballot secrecy, a fundamental right to make an informed choice, yet the definitive core, the actual act of electing a representative, remains a mere statutory entitlement. We possess fundamental rights for the mechanics of choice, but entirely lack them for the choice itself. And that brings us to what we can call the 2013 NOTA anomaly. The court held that a voter's decision to reject all candidates is a form of political expression that is fully protected by Article 19(1)(a). So wrap your head around this. The right to not vote enjoys fundamental constitutional protection, but the core right to vote, that remains completely unprotected as a fundamental right. It is just an extraordinary constitutional anomaly. Moving on to Section 3, the basic structure doctrine. So how do we actually resolve this incongruity for your mains analysis? Let's look at it through the prism of broader constitutional principles. Ever since the landmark 1973 Keshavananda Bharati case, it's been a settled fact that certain unalterable features form the Constitution's basic structure. A couple of years after that, in the 1975 Indira Nehru Gandhi case, the court explicitly underscored that democracy and free and fair elections are absolutely essential features of this basic structure. Here is the crucial synthesis. Democracy does not exist in the abstract, right?
It operates through elections, and it derives its legitimacy exclusively from citizen participation through the ballot. So to say that democracy is basic to the Constitution, while simultaneously claiming that the citizens' vote, which is the indivisible core of that democracy, is merely a statutory right, is completely incongruous. A democracy without voters is simply inconceivable. You cannot protect the building while leaving its foundational pillars entirely exposed to the whims of ordinary legislation.
Let's dive into Section 4, Article 326, the Foundation. Thankfully, we don't have to look very far to find an anchor that rescues our statutory orphan. It becomes super evident when we examine Article 326 of the Constitution. It states, in a very clear constitutional command, that elections to the Lok Sabha and state legislative assemblies shall be based on universal adult suffrage. What does this mean for us? It means every citizen above the age of 18 is constitutionally entitled to be registered as an elector, subject only to some very narrowly defined disqualifications. The true source of this entitlement isn't legislation at all. It is the Constitution itself. Think of it kind of like a building construction. The Representation of the People Act is merely the scaffolding. Yes, Parliament has to prescribe qualifications, manage electoral rolls, and create rules against corrupt practices. Those regulatory provisions are absolutely indispensable for orderly elections. But that scaffolding rests on a solid, concrete foundation, and that foundation is Article 326. The mechanics of voting may be statutory, but the citizen's fundamental entitlement to be a voter flows directly from the Constitution. And finally, Section 5, the way forward. The good news is the judicial paradigm is honestly already starting to shift. In the recent 2023 Anup Baranwal case, we saw a massive signal from the bench. Justice Ajay Rastogi, in his separate opinion, expressly favored recognizing voting as a fundamental right. And while his specific view didn't command a majority, the broader Constitution bench repeatedly referred to voting as a constitutional right rather than just a statutory one. The momentum is absolutely shifting away from those narrow, restrictive conceptions of the 1950s. So, what is the actionable path forward here? First, it's high time for the Supreme Court to formally revisit that obsolete 1952 doctrine forged back in the infancy of the Republic. Second, we must legally recognize voting for what it truly is, the fundamental instrument through which popular sovereignty is expressed. Third, we need to completely realign the right to elect with the basic structure doctrine, making sure that the right to choose a government is given the highest possible constitutional armor. And finally, we've got to definitively elevate the vote beyond a mere legislative privilege conferred by Parliament. To wrap up our analysis today, in a constitution where democracy and free and fair elections constitute the basic structure, the citizen's vote simply can no longer remain a statutory orphan. It's the very mechanism through which the Republic periodically renews its democratic legitimacy. It deserves, and frankly, it demands, fundamental protection. I'm going to leave you with this really inescapable, provocative question, one that perfectly encapsulates the paradox we've unpacked today. If the Constitution explicitly protects the right to reject all candidates, how can it scarcely deny protection to the right to choose one? Think about that paradox. Thank you so much for joining me on this explainer. I really hope this deep dive gave you a powerful, fresh framework for understanding our democracy and helps you crush those upcoming exams.